Good afternoon. Welcome to the afternoon, the remainder of our January call. The first case up this afternoon is Amy and Robert McCormick versus Michigan State University. I feel like I have to say go green anytime I say that. This is a mini oral argument on the application, 15 minutes per side. You have 2 minutes, a fire-free zone. And if you would like to reserve any time for rebuttal, you may do so, but just try and keep track of it yourself. Thank you.
May it please the court, Elizabeth Watsa on behalf of defendant appellant Michigan State University. At this time, I would like to reserve 2 minutes for rebuttal, please. Immunity bars plaintiff's claims for failure to comply with 6431 and 5855 cannot and does not here save plaintiff's untimely claims. This court should reverse and remand for 2 clear, independent reasons. First, 5855 may not toll 6431's notice provision. And that's supported by 6431's plain language, except as otherwise provided in this section, and this court's very recent opinion in Christie. However, Your Honors, it's not necessary to resolve this issue today. This court should exercise judicial restraint and instead decline to rule on whether 5855 applies to 6431 because it's not necessary to the decision. However, what is necessary to this decision, Your Honors, is that 5855 does not apply to the facts of this case. And that is because of several reasons. One, 5855 by its plain language only applies to toll statutes of limitations, not notice provisions when it is applicable. And 5855 is not applicable here because of several reasons. One, the alleged fraudulent concealment occurred before the alleged injury and incurrence of liability. 2, the plaintiffs did not conduct a diligent investigation or diligently pursue their claims against Michigan State University. And 3, plaintiffs were aware, even after the alleged fraudulent concealment, they believed that they had claims against Michigan State University. And at this time, I'd like to waive the rest of my free fire time.
Can I ask, you would agree that the legislature extended the statute of limitations for fraudulent concealment, or based on fraudulent concealment for a claim against the state, correct? The statute of limitations was extended.
Yes. Oh,
okay.
I see where you're going,
Sorry.
Your Honor. No, I apologize.
Should have been clear. So can you give me an example? Is there any circumstance in which a plaintiff who was, whose cause of action or liable party was fraudulently concealed would be able to take advantage of that extended statute of limitations if the notice provision is not similarly extended?
Yes, absolutely, Your Honor. So you're discussing the fact that the Court of Claims Act, the legislature specifically incorporated the RJA and thus 5855 into the statute of limitations, which again makes sense because the statute of limitations per 5855's specific plain language is what can be told, not notice provisions. And I understand your question, Your Honor. Justice Kavanaugh, you're asking if 5855 applies, how can it apply to both the statute of limitations and also the notice provision?
Well, how can they take advantage of an extended statute of limitations?
Sure.
If they've already blown the notice period?
Understandable, Your Honor, and there may be certainly circumstances where that is the case, where plaintiffs do not meet the requirements of 6431 and are thus unable to pursue their claims because they failed to comply with 6431, and 5855 does not save them there. But again, it's the legislature decides. It's the legislature's job to decide when and how plaintiffs can sue the state or any
I
other
get that,
defendant.
but is there any scenario, given that you have a 1-year statute of limitations that then, in theory, can get extended an additional 2 years, and you have a 6-month limitations period?
Or 1 year, Your Honor, yes.
Or 1 year. So is there any time where you get more time, you get an extended statute of limitations, and you still are able to comply with the shorter notice requirement?
Sure, Your Honors. If the plaintiffs, for example, here had done a diligent inquiry, they could have filed suit within 1 year of the notice period. And that's certainly because,
Well, we're assuming, though, that their cause of action and, or in this case, the party was fraudulently concealed. And that, therefore, they get the benefit of an extended 2-year statute of limitations. So they couldn't have filed it within the original 1-year statute of limitations because it was concealed from them. So we're assuming that we're in that realm of fraudulently concealed. They get an additional 2 years. Wouldn't it, by just de facto, like the earlier, shorter notice period that, under your argument, does not get extended, would necessarily expire in every case?
yes, Your Honor, if 5855 does apply here, or in any case, because again, it does not apply here, but theoretically, if 5855 did apply, then yes, that is the scheme the legislature has set forward. And again, it's very clear. 5855 specifically only applies to statute of limitations, and 6431 is very, very clear in its language. In 2020, it was amended to add this express limiting language, which is except as otherwise provided herein, within 6431 itself. Plaintiffs, in order to sue the state, they have to give the state notice. And that has to be within 6 months for personal injury claims or 1 year for claims such as plaintiff's claims, which is contract claims. And again, this court recently, very recently, 2.5 years ago, in fact, in Christie, did hold that express limiting language in 6431 did apply to only exceptions within 6431 itself, which are only for WICA claims, Your Honors. That's the only exception here, and that's very clear.
Well, but Christie didn't deal with this issue, correct? Christie dealt with whether or not a notice needed to be filed, even when filed in circuit court.
Christie dealt with, respectfully, Your Honors, Christie dealt with 6431 and its applicability to where plaintiffs have filed cases outside of the Court of Claims Act. And this court rightfully held that regardless of the forum, 6431 applies and plaintiffs need to comply with it in order to sue the state. Because the Court of Claims Act is the state's waiver of sovereign immunity. However, Your Honors, although that's the very narrow holding of Christie, there's no reason why Christie would not be applicable to this situation where the only exception in Christie and under the plain language of 6431, the only exception to the notice provisions is within 6431 itself, and that again is only for WICA claims, not plaintiff's contract claims here.
But you acknowledge that requires an expansive reading of Christie.
Pardon me?
You acknowledge that that requires us to read Christie expansively.
Your Honors, I don't believe it's an expansive reading. I think it's a plain reading. There's certainly quotations within and throughout Christie that equally apply here. The question here is, does 6431 have an exception that's not in 6431? That's the broad question here, and that was the same broad question that Christie did answer, and the answer is no. The only exception is WICA claims. Otherwise, if we interpret 6431 as plaintiffs suggest, then we're rendering 6431's exclusive language of except as otherwise provided in this section as completely nugatory. If we incorporate the whole of the RJA, including 5855, we're putting in a statutory exception that does not exist. Perhaps before the 2020 amendment and that language, except as otherwise provided in this section, perhaps the Mays 1 court, the Court of Appeals case from 2018, perhaps they had an appropriate reading. But here it's simply very, very clear. And because of the plain language, because of this express limiting language in 2020, it's not appropriate to engage in statutory construction, Your Honors, because then we get into an issue of the judiciary weighing in on and reconsidering what the legislature has already in its wisdom provided. And again, it's the legislature's job to decide how and who and how the state can be sued. And they've done so here, and it's very clear that 6431 says, and this court held in Christie, the only way to get around 6431 is for WICA claims. Otherwise, plaintiffs have to comply, or the cases are barred by immunity. And again, that's because the Court of Claims Act in general is this state's waiver of sovereign immunity, and those waivers must be interpreted very, very narrowly.
Counsel, I'd like to just turn to the final question that was asked about the sort of claim accrual. So what is your view when plaintiff's claim accrued?
Absolutely, Your Honor. And actually, until recently, this was not an issue in this case. So plaintiff Ms. McCormick, Amy McCormick, was terminated by the College of Law on December 31st, 2019. That has been an undisputed issue throughout the appeal until this court asked this question. And it's very clear from, first of all, statutory language. 6257, I believe, provides this legislature's scheme, if it were, on when claims accrue. And the rule is, generally speaking, claims accrue at the time of the wrong upon which is done. And that's supported by this court in a few cases, including Frank v. Linkner. And that makes sense here because, generally speaking, contract claims accrue at the time of the alleged breach. Here, plaintiffs clearly have alleged in their complaint that the alleged breach was the termination of Amy McCormick's contract.
Okay, so you're saying, okay, understood the way the case is pled. Do you agree with the notion that if fraudulent concealment is alleged, that a claim can accrue later, realizing it's an allegation, but like if a claim is covered up, not getting into the whole, was it before the breach or what not, but we obviously have case law that if fraudulent concealment has happened, it does toll the limitations period, and it sort of resets when the claim starts.
Your Honor, I agree that when the fraudulent concealment statute is met, when 5855 it applies, it can clearly toll the statute of limitations. And that has been case law for many years. Only recently did this court in McLean, which plaintiff's counsel noted in their most recent brief, did they touch on 5855. But again, that was dicta. That was not, 5855 was not at issue in that case. It was not briefed by the parties. And it's very clear that 5855, again, by its own plain language, it talks about tolling the statute of limitations period. Does not talk about tolling a notice provision. Does not talk about accrual. So in 5827, there are specific sections that the legislature can amend, can change the accrual date. And in those specific sections, the word accrual in some form is used. For example, the legislature has provided for alimony claims, for example, that they accrue when each payment is due and missed. So here, 5855 certainly is not within the range of statutes that the legislature can use to change the accrual date. But more importantly, too, Your Honors, is that 5855 mentions nothing about accrual. It's not specific whatsoever. And certainly, Your Honors, when there's a general rule for the legislature as well, the legislature in 5827 has also said for the general rule for when statutes of limitations start to run. And that applies here, and it's at the date of accrual, but the legislature may specifically alter that, not within any specific sections. They can do it wherever they want, in any statute, and that's clearly what they've done here, and that's supported by this court in Trentadue and also by Frank v. Linkner. And this court, But again, this issue, this third issue, the accrual issue, again, this court does not even need to answer this question because it is very clear that 5855 doesn't apply. And that's for several reasons. So again, 5855 specifically in its clear language talks about limitations periods, not notice periods. Two,
Counselor, I'll let you finish, but I'm just sort of the practicalities of this, right? So imagine, so DCL at the time that this happened was a private entity, it wasn't a state entity, right?
yes.
And so imagine there actually was a fraudulent concealment. How would a party even know to file a notice if they believe they have to file against a private entity when in fact the fraudulent concealment doesn't permit them to understand that it's in fact the state they have to file against? Do you see that? Like, what should happen there under your reading of the statute?
Absolutely, Your Honor, and that leads me to my next point. The reason 5855, another reason it doesn't apply is because there was no diligent inquiry, Your Honor, and that statute 5855 specifically says that the 2-year period starts not only if the plaintiffs discover the claim or the liable party, but when they should have. And that's the diligent inquiry piece, Your Honors. And for example, Michigan State University is a public entity. It's subject to FOIA. But instead of plaintiffs arguing that they, or pleading that they conducted a diligent inquiry to pursue their claims, they simply said they believed what they were allegedly told and sat on their hands for 2 years and sued a defunct entity 2 years later. Thank you, Your Honors.
Thank you.
Good afternoon. May it please the court, I am Mark Cousins, appearing on behalf of plaintiffs appellees. Plaintiffs' notice of intent was timely because Michigan State University fraudulently concealed its responsibilities for the liabilities of the Detroit College of Law. And Section 5855 of the RJA applies to the notice requirement of 6431. The court has asked 3 questions. Plaintiffs say in response, first, 5855 applies to the notice requirement of 6431 because 6431 is part of the Revised Judicature Act, as is the entire Court of Claims Act. 6431 is subject to the RJA, and that means it's subject to 5855. Second, Doe versus Archbishop is not relevant here because in that case, the identity of the responsible party, in our case, the identity of the responsible party was concealed, and in Doe, a plaintiff claimed that the existence of a cause of action was concealed. Different parts of 5855, the case, which is not the Court of Appeals' best decision, reminded me a lot of a religious text where the more you read it, the more you disagree with it. The case considers a different cause of action. And third, the plaintiff's cause of action against Michigan State University accrued when the university finally disclosed that it had accepted the liabilities of the Detroit College of Law. What happened before that is irrelevant, and the Henry case, the cases the court cited, relate to harm. We know when the harm occurred, but who do you sue? A cause of action cannot accrue if you have no idea who the defendant might be. And in this case, the identity of the defendant was concealed. Now, 5855 applies to the notice provisions of 6431. Why? First, the court should not render 5855 nugatory in whole or in part. The arguments of the Attorney General and the university would, in fact, render it nugatory regarding an entire class of actions. They want this court to nullify 5855 as it pertains to the state and its agencies. That is not the role of the court. They justify this by asking the court to read into Section 5855 a limitation that is not there. The requirements of 6431 do not supersede the rest of the RJA or prohibit application of 5855 where appropriate. There are no exceptions in 5855. It applies to all litigation. Yes, Judge.
You argue that the fraudulent concealment provisions of 5855 should apply to the Court of Claims Act because they're both in the RJA.
Yes, sir.
But doesn't that argument effectively import extra statutory language that would expand the Court of Appeals, or the Court of Claims Act?
Your Honor, I'm a bit
beyond-
hearing impaired, and I'm sorry I can't hear you.
Okay. Doesn't that argument effectively import additional language into the Court of Claims Act and add things other than what is expressly stated, and that's an exception or a carve-out for WICA, the wrongfully incarcerated person, claim act?
Respectfully, Your Honor, I don't think so. I think
Why?
you read 5855 as to what it says. In the case of a fraudulent concealment, a claim may be brought within 2 years of discovery. The statute is very clear. It is a license to proceed to litigation under certain circumstances, irrespective of other statutory or common law limitations. And once a plaintiff discovers that an event, the identity of a party or the existence of a cause of action has been fraudulently concealed, they have 2 years to file suit. That's what the statute says. It is viewed, or the court should view it, as a circuit breaker that the legislature created for unusual circumstances where individuals have been harmed by the misrepresentations of others. And the court, in reaching this decision, should read 5855 in context. 5855 is part of the RJA, and the court should read that statute, which has 91 chapters, as a comprehensive section, a comprehensive whole, and read 6431 in context. No part of that section of the RJA should be read in isolation. In context,
Counselor, how do we address the section that Chief Justice was speaking to, 6452, that explicitly incorporates, or appears to explicitly incorporate in the statute of limitations the fraudulent concealment? So the argument of defendant is that that's explicitly incorporated in that section, and so we cannot read it into 6431. How do you address that?
I read 5855 as an express license created by the legislature for an unusual set of circumstances, which by its very language permits a plaintiff to proceed under certain facts. And reading the RJA as a whole, 5855 trumps other limitations, no matter where they are in the RJA. So now, 5855 isn't going to happen every week. It is an extreme set of circumstances, and in this case, my friend Ms. Watsa has been talking about diligent inquiry. Diligent inquiry. We have an email from the attorney for Michigan State University that told the plaintiffs that their cause of action was to be filed against the Detroit College of Law.
What do we do with, even assuming your characterization of this as being 5855 being sort of the circuit breaker, and it's the rare case and it extends that, but the language of 5855 specifically says the period of limitations.
That's true. My answer to that, when I read the statute for the first time, was that the legislature was sloppy. And the limitations period, the use of the term limitations, was designed to fit with the 2-year period, so that any bar, any statutory or common law bar to a plaintiff proceeding under admittedly very unique circumstances is set aside. And if they're lied to, if a party is deceived, they may file suit within 2 years, and anything to the contrary notwithstanding.
Is there anything to be taken from earlier in the sentence where it says that the action may be commenced at any time within 2 years, and then also at the very end it does say otherwise barred by the period of limitations?
Well,
Should we import any meaning into may be commenced as extending to a notice provision, which is required to commence an action against the state?
having tried to assist the legislature from time to time writing labor legislation, I can tell you that writing laws, as this court knows, is not an exact science. What I see in this statute is the phrase, "the person who is entitled to bring the action discovers," and then is entitled to sue. When you read all of this, all of the components together, what the legislature is saying in 5855 is you can sue if you're defrauded. And anything that gets in the way gets set aside. Why? Because as a matter of policy, individuals, including the state, perhaps especially the state, should not be permitted to escape their misconduct. That's what the legislature said in this. Where a defendant or potential defendant engages in conduct which inhibits a person from securing a right which is lawfully theirs, we're not going to put artificial barriers in the way. That is why the university's argument with regard to Christie is wrong, and with regard to 2020 PA 42 is wrong. Christie, a very well-written opinion by Justice Zara, says pretty clearly what you have to do is file the notice of intent no matter where your cause of action is launched. I understand that. Makes complete sense, but it doesn't say anything else. It's very clear with regard to what a plaintiff might do, and the plaintiffs in this case filed a notice of intent. They meet the obligations created by Christie. As regards 2020 PA 42, that statute made 23 changes in 6431. It didn't add a barrier. The state is saying to you, take a look at this statute, which didn't deal with limitations or notice periods, and read into it something that is not there, simply because the statute allows a party to proceed under a specific right granted by the legislature under another statute doesn't mean that the legislature also barred the application of 5855. It's too far a reach. The state of Michigan and the Attorney General and the university have argued about the consequences of applying 5855 to 6431. The answer is really very simple. Don't lie. Don't mislead people. Don't try to evade liability with false statements, which is precisely what happened here. Were they willful or deliberate? I don't know. Discovery will show that. All I do know is that the plaintiffs were misled, and when they discovered the truth, they acted promptly in a manner which the statute requires by filing a notice of intent and proceeding. Now, if I may, I'll address Doe. The decision in Doe is not guidance regarding the question in this case. The court in dicta, Court of Appeals in dicta, said that only actions after the alleged injury could have concealed plaintiff's causes of action. Well, to begin with, we're talking about a different matter here. This is concealment of the identity of the responsible party. Concealment before an injury, I think, can be relevant where a party delays filing an action. If something occurs which dissuades someone from filing, whether it's concealment of a cause of action or the identity of the responsible party, that is an explanation why they delayed. And therefore, I think the dicta in the Court of Appeals is not correct. That the case itself is interesting. It's a unique set of circumstances. Our heart goes out to the plaintiff in that case. Whether the Court of Appeals got the case right or not, I don't know. But I do know that the dicta really is no help here. As regards the final question, which is when plaintiff's cause of action accrued. Plaintiff's cause of action accrued when they discovered that Michigan State was the responsible party here. Michigan State had expressly denied its liability in an email from its attorney to the plaintiffs. And as a result, plaintiffs believed what they were told. Plaintiffs, intelligent, competent, very capable law professors, got told, you have to sue DCL. So they did. And when they sued DCL, DCL said, hey, don't look at us. Look at them. In the middle of an argument on a motion for summary disposition, Michigan State University pops up a contract which the plaintiffs had never seen and said, oh, guess what? Michigan State took over the liabilities of DCL. That was the first time plaintiffs heard that, and that was the first time they learned about it. That's when their cause of action accrued. And they proceeded promptly against Michigan State. And having done so, their claim is timely under 5855.
Counsel, if you could just address the accrual of the claim, the third question we asked the parties in this case. Obviously, Michigan State has a different view, I'm guessing, on when the claim accrued. So I was wondering if you could address that.
They look at the breach of contract, and they look at very traditional common law that says when you breach a contract, that's when the cause of action accrues. But we have a different situation here. The situation is Michigan State hid its liability. Now, this court should not endorse the ability of a defendant to hide behind lies and misrepresentations in order to permit a statute of limitations to run. The whole point here is Michigan State deliberately or not deliberately misled the plaintiffs. And as a result, plaintiffs could not have known that they should have sued Michigan State. And when they learned, that's when they filed suit. That's why the cause of action against Michigan State accrues. Because what the court has asked is a general question. When does the cause of action accrue? Well, typically when the contract is breached. But there's another question to be asked. When does a cause of action accrue against this defendant? And in this case, the cause of action accrued against Michigan State when Michigan State finally owned up to its responsibilities.
Counsel, fair to say that based on what you just said, we would be working with a different point of accrual if DCL still existed.
Oh,
If DCL was still in existence, you would have a different answer to that question than the facts that we have here where MSU is assuming DCL's liabilities.
If DCL continued to exist, we wouldn't be here because we would have proceeded against DCL and prevailed in our cause of action in the circuit court. But the circuit judge found that DCL had gone out of business and therefore under the Business Corporation Act couldn't be sued. I disagreed with the circuit court's decision, but the Court of Appeals agreed with it, and that put an end to that. That is why we want, after discovering that Michigan State was responsible, the lawsuit was filed. I see I am out of time. I am grateful for the court's attention. Thank you very much.
Thank you. The case will be submitted. I don't think, we didn't have any remaining time. I think we used all your time. Thank you. We will submit the case.